Yes,
Ma'am, I can join me now. It will not, I could not take instruction for following 8 minutes.
item 21.
21.
Okay. On the
Taken in-
pair being made by Mr. A. Rosid, learned counsel for the petitioner. You inform the other side. With
I have informed.
consent from the other side. Press for listing the matter after
On 4th or 5th minute, you know, on
4th of
8 December.
8 December.
Sorry.
Pair allowed. Yes, Khadania.
Make to mention item number 29 and 30. madam.
29 and
That
30.
will be taken up after 3 days, madam. I've taken the concept of the other sets.
Mr. Atonier, learned standing counsel for the elementary education department with consent from the other side. Press for listing the matter after
After 10 days.
after 10 days. Pair allowed. That was deposited, Mr. Khatone.
Today we will, madam, in fact, we have filed in at least today, madam. Accepting the post, madam. There are some reasons grounds, madam. So that is why I am making mention, madam. I think an affidavit, today we are filing that affidavit. That is why we'll,
Okay, after 10 days.
after 10 days.
COVID, date fixed the date.
December.
Ah.
I get to mention my lord 2 items for motion, Monday or Wednesday, as well as.
One day may not be possible.
But
Is there any urgency?
One is urgent and one maybe on Wednesday.
One on 28, one on first.
Yes.
Please, your lordship, with the due consent of the other side, I'd like to mention item number 16 to 21, three. Matter my lord, Kaushik is saying in this matter, he's my lord on bereavement. He's on bereavement, therefore I pray my lord, the matter may be taken up after 2 weeks. I've taken the consent of the other side.
16 to 20.
Lordship, I am from the petitioners in item number 17, your lordship.
Hmm.
However, I would kindly pray your lordship may fix a date, your lordship.
Mr. A. Fukan, learned standing counsel for the elementary education department, appearing on behalf of Mr. Kaushik. Learned counsel. Learned standing counsel for the elementary education department with consent from the other side. Did you inform all the petitioners?
Inform.
You have informed.
Yes, your lord.
Price for listening the matter after 2 weeks.
2 weeks.
Lordship, a date may be fixed, your lordship.
There are a lot or SSL list the matter on
12 December.
list the matters on 12 December.
Possibly.
For admin or last day.
When do you want?
26.
26.
December first week, on 3rd December.
Lordship, for listening to matter for admission, Lordship. December 1st week, if possible, Lordship.
December first week. Okay.
On 5th and on 8th. Whom is right?
Lordship, I pray for listing a new meter along 6 from November.
When?
Wednesday, Lordship.
Okay. So when?
On Wednesday, 26.
26.
Yes.
May I bless your lordship, therefore listing lordship, contempt case lordship. Pick any date lordship,
Contempt.
contempt.
Okay. Okay.
28 November.
It's very easy, your lordship. Lordship, I beg to mention item number 44 on the supplement. Not only praying for adjournment with the consent of the petition.
44.
44.
It is motion matter.
On behalf of standing council NC Hills.
Standing council.
NC Hills Education.
NC does.
NC Hills, my lords, R.
Oh.
Kaushik, on behalf of R.
RR.
Kaushik,
RR Kosek. Mr. Your good name, please.
R. Ghosh.
R. Ghosh, learned counsel appearing on behalf of Mr. RR Kosik, learned
Lord,
standing counsel for the NC Hills. With consent from the other side, press for listing the matter on
My lords, there's another writ petition arising from the same selection process. That writ petition has been listed on 11th December.
11.
Yes.
Okay. Fair allowed.
Okay.
So do I take this matter or with that matter?
Yes, my lords, on that.
The
matter,
learned
records have been
counsel also submits that this matter is connected with the writ petition number
6495
6495 of
of
2025.
25. My lords.
and price for listing the matter together, pair allowed, rest shall do the needful. Yes,
May I please, your lordship?
which matter?
44.
Okay. Interim order pass earlier shall continue.
May I please, your lordship, I beg to mention word and orders matter, my lord.
When?
Next week, my lord. Yes,
27.
first of this.
Yes,
Admission करना
when?
next week thanks.
Next week.
December,
May I please, your lordship?
on 1st December.
May I please, your lordship? Lordship, I beg to mention item for listing, IA for listing, your lordship,
When?
on Monday, your lordship.
Monday may not be possible.
The reason I'm.
Okay, one.
Oblige, your lordship.
I recommend restriction for admission merit in next week in any day.
Next week may not be possible.
December first week. Yes, December.
Yes,
Lord, I have a similar prayer for listing for admission, my lord. Some urgency is also there. So that may I pray, my lord.
Kaveh.
3rd December.
Uh,
3rd December.
Some earlier date.
27, 28.
28,
My lord.
28.
Okay.
Item from daily list. Item number 1. Motion maker.
May it please, your lordship.
So, thing and instruction of this, and yesterday, the hearing was set for 6, it now was also called for some discrepancy has been found, so we need to find this illegally in that sense. At this stage, notice that notice may be issued to find the affidavit and the response of the governing body and inspection committee.
Will?
Response of the governing body and the selection committee of the college will also be required. Notice may be. Notice has not.
What is the outcome of the hearing?
No, it is under process. Some discrepancy has been found there. Petitioner was also called for, he was also there. And.
That's it,
College has been directed to.
Lordship, this was the notice issued to me on 18/11. Hearing on yesterday, lordship. If I go through the notice, lordship, it confirms that this notice was in connection with election of Sutata Borgohai as the respondent number 6, lordship. So, lordship,
Okay, you file your affidavit.
till then, lordship, no final appointment, lordship. Because lordship, let them file the affidavit, lordship, till then at least no final appointment.
They have not finalized the process. The hearing is going on.
And the election committee response is also required, then only lordship everything will come into line. We will also file detailed affidavits because hearing is going on, notice.
Selection committee is a party in this.
Yes, yes,
proceeding.
lordship. Yes.
I have made them party, lordship.
Because they are the person who has. They were the.
The respondent number 5, lordship, that's why, lordship.
Respondent number
I
5.
meantime, lordship.
They have to hamper, if it's very given, it will hamper everything.
No, hearing may be done, lordship, in the meantime, but they should not finalize it, lordship. That is what I am praying, lordship.
I am saying that notice may be issued.
I have already participated in the hearing yesterday also, lordship. They,
If he is interested, he will get notice. Nothing like that.
Heard Mr. Kapil, learned counsel for the petitioner. Mr. Tobelder, learned standing counsel for the respondent number 1 and 2.
Not.
Mr. Tobelder submits that though he was directed to obtain instruction, yet as per his instruction yesterday, one hearing was conducted by the respondent number 1 and 2, wherein the present petitioner also remained present. And
The college authority was also called for. College authority were also called for in the hearing.
and the college authority was also called for to the said hearing. And the hearing is under hearing is and the hearing is going on, and he priced for issuing notice to the respondents as response from the selection committee is also required. Will also be required for adjudication of the dispute in the present petition. And he pressed for listing the matter after 2 weeks. After 2 weeks. After 2 weeks. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that notice be issued to the respondents returnable in 2 weeks. However, no formal notice is required to be issued to the respondent number 1 and 2. Since Mr. Tobilder entered appearance and received notice, however, extra requisite copy of the petition be furnished to him during the course of the day. Slip upon respondent, rest of the respondent be taken by registered post with AD and also by usual process within 2 working days from today. Additionally, dusty service is also permitted. After effecting service upon the respondent number 3, 4, 5, and 6, the petitioner shall file an affidavit before this court. Lays the matter on
10th December.
10th.
And
10th
Well,
December.
Lordship, be on, 10.
12 December.
No, I'm saying just only that no final decision may be taken because the matter is subject before
Final,
Sovereign Court.
final decision, the question of final decision.
Without
does
leave
not
of this court, must be recorded that no final decision will be
No,
taken.
no, no.
And number 2,
May it please, your lordship. So the issue herein is, my lord, my service have not been provincialized as my name does not reflect in Dias code, my lord.
Hmm,
I'm a teacher, my lord, I'm a lecturer in a junior college.
hmm,
And lordship knows that as per the 2017 Act,
hmm,
there is no requirement for a teacher of junior college
hmm.
to be, as his name to be reflected in the Dias code, my lord. The matter has already been covered. Before that, my lord, my. Okay. Secondary thing.
Yes.
Page 27, my lord. This is my appointment order, my lord. In Kolatoli Katmi Ansolik Junior College, 4/8/2001. This is my joining and my appointment order, lordship will find it 20.
Doctor, you are appearing for?
1, 2, and 3.
1, 2, and 3.
And my name has already been forwarded by the district level committee, my lord. For tutor, second.
Who rejected the
My lord,
claim?
paragraph 9, my lord, there is no such rejection, my lord. Paragraph 11, my lord. Of my petition.
If the recommendation of the district level committee is not
My lord.
rejected, then how the cause of
My lord,
action
paragraph
arises?
11, my lord. Paragraph 11 may kindly be perused of my writ petition, my lord. As my service was not provincialized, I filed in representation. And thereafter, my lord, paragraph 11. That a petitioner begs to state that the representation dated 9/2/2021 filed by the petitioner has not been able to yield any response from the respondent number 2 till date. Therefore, the petitioner recently visited the office of the respondent number 2, where from the petitioner came to learn that the service of the petitioner could not be provincialized, as the name of the petitioner does not reflect in the Dias code for a school up to 2009-10. It is pertinent to mention herein that the Act of 2017 does not have any requirement requiring the names of the teacher of senior secondary schools to be included in the Dias code.
No, you tell me what is the basis of this information?
My lord,
What is the basis?
basis of which, man?
Hmm? That due to non-availability of gas code, your service is
My lord,
not
as I
being
have
mentioned.
indicated, my lord, I inquired with matter with the. And there I came to learn that my service was not provincialized as my name was not reflected in the Dias code. At paragraph 11, my lord. And
No, that is your only statement.
My lord, similarly placed teachers have already approached your lordship, my lord. Where, my lord, a order was passed directing the respondent authorities to provincialize my service, to take a step to provincialize my service without insisting to the Dias code, my lord. If lordship reviews page 37, these are the teachers similarly placed with the petitioner, my lord. Page 38, lordship will find the name of Muhammad Noor Islam. He is one of the teacher of our college, my lord. Next page 40, Afzal Hussain. And next 41, Abdul Rahim.
So you want similar order to be.
Similar
part of
order,
this
my lord.
petition?
Similar order. That I consideration, my lord.
Petition is similar to those which are shown. So let notice go lordship, to respond if it is similar.
My lord, instruction may be taken, my lord. We are praying for similar relief. My lord. We are not praying for provincialization of service, my lord. We are praying similar relief so that to consider our case for provincialization without insisting on the Dias code, my lord, which is not a requirement as per the 2017 Act, my lord. Lordship, it is a page 51, paragraph 6. When I am relying. Paragraph 6 at page
Okay,
50.
let him obtain instruction.
Yes,
thereafter
instruction.
we'll
The
consider
short date may
your
be
case.
fixed, my lord.
Heard,
Instruction.
Mr. Your good name, please.
RM Deka.
R.M. Dekar, learned counsel for the petitioner. And Mr. Dotto, learned standing counsel for the respondent number 1, 2, and 3. 1, 2, and 3. In this petition under Article 226 of the Constitution of India, the petitioner has rightful receiving direction to the respondent authorities to forthwith provincialize the service of the petitioner as tutor in the Department of Assamese at Kalatali, Kathmi Ansolik Senior Secondary School in Kamrup District. Kamrup District. Mr. Dekka, learned counsel for the petitioner, submits that the petitioner has been working as teacher, as lecturer in at Kalatali Kathmi Ansolik College, within bracket junior, since the year 2001. And the same college was later on amalgamated with Kalatali Kathmi Ansolik Senior Secondary School. And though the district level committee has recommended for provincialization of service of the petitioner, yet the service of the petitioner has not been provincialized, and the petitioner came to know that due to non-reflection of his name in the Dias code, his service was not provincialized. Mr. Dekka further submits that similarly situated teachers have approached this court by filing WPC number 5883 of 2024, and a coordinate bench of this court order dated 28/3/2025 has disposed of the writ petition, said writ petition, directing the respondent authorities to consider the case of the petitioners for provincialization of their services. After making necessary verification as per the provision of the Act of 2017 without necessitating upon their name being captured in the Dias Code of 2009 and 10 as provided in the said case. That is, in the case of Kishore Kumar Nath and others versus State of Assam, reported in 2023 SCC Online GAU 1487. And this petition may also be disposed of by granting similar relief similar relief to the petitioner. That this is Mr. Dotto submits that he may be granted some time to obtain instruction. Where is allowed, rest is the matter on. Fifth of December, Mr. Dotto shall obtain necessary instruction in this regard and place the same before this court on next day. This
My lord,
recording.
item number 3 and 10 are similar, my lord.
Item number
Three.
3 and 10.
3 and 10. And this is, my lord.
Item number 10. Okay, you obtain instruction.
Deeply obliged, lordship.
Item 4.
May I please your lordship? My lord, the petitioner was initially appointed as a lecturer, again non-sanctioned post in the year 1999. Subsequently, lordship, his service has been regularized in the year 2018. Your lordship will find at page 20. Regularization order imposing on condition. Your lordship will see condition number 2. The incumbent concerned will be required to qualify net slate PhD within 2 years. Otherwise, his service will be discontinued. Until then, he will be entitled to get pay as prescribed only from the date of joining subsequent to this order. My lord, the petitioner has obtained PhD degree. After regularization, in the next month, lordship, he has applied for a PhD degree. And certain procedure he has to follow. Lordship, after that, lordship, on 26 for lordship 11/10/2018, he got admission. Lordship, after that, lordship, within a period of he has been awarded lordship PhD degree on 2/7/2024. During this period, lordship, from the date of admission, it requires 5 years, 8 months, 21 days. As per UGC norms, your lordship will see that minimum 3 years will be required and maximum 6 years, including one extension period. He can obtain lordship PhD degree. No one can lordship obtain PhD degree within 2 years. Lordship, I have the UGC regulations.
UGC is a party here.
After obtaining PhD degree, lordship, I
No, you have
applied.
not arrived the UGC as party. Yeah.
Lordship, university, lordship, Cotton University, I have been made party. Lordship, regulation number 4, next page, lordship. Yes. Duration of the program. 4.2, your lordship will see. PhD program shall be a minimum duration of 3 years, including coursework, and a maximum of 6 years. My lord, during this period, corona pandemic situation was there. More than lordship 1 month was required to hold the meeting of regulatory advisory committee. And without lordship fail, the petitioner has completed lordship the PhD degree. Now, lordship, they have rejected my claim on the ground that I did not.
Your claim was for
lordship that my service has been regularized with a condition, lordship, that regularization period page 20, your lordship. I am getting fixed pay. After regularization, I am getting fixed pay, and pay scale has not been given imposing that condition, lordship. If now I have completed PhD degree, so the petitioner is entitled for scale of pay. And
yes, Mr. Tobel there.
This may go ahead.
So if the UGC regulation provides that duration shall be minimum of 3 years,
And maximum 6 years.
then
This condition was there in the appointment letter. Notice may go, we verify.
Yes.
And I did for the university, my lord.
Hmm.
We are a model family. Yes, sir, the freelance is not directed against.
Against the higher education department.
Yes, it is.
Mr. M. Khan, learned counsel for the petitioner. Mr. Towilder for the respondent number 1, 2, no, 1 and 3.
One,
One, two,
Mr. Soliha for 2.
yeah, one and
one and two.
Copy lordship, my page is.
And Mr. P.D. Nair, learned standing counsel for the respondent number 4. Respondent number 4. In this petition under Article 226 of the Constitution of India, the petitioner has challenged the letter dated 19/3/2025. Annexer.
Yes, 47 imprint letter.
Yes.
47 imprint data. My lord, one imprint letter, 8/1/2025, I could not be annexed. That is the government letter. Lordship, I file an application, RTI application. Lordship, I have got that letter. I'll file an additional affidavit bringing that letter.
Letter dated 19/3/2025, within bracket annexer 23 issued by the respondent number 3. By which the respondent number 1 and 2, no, 1 and 3. 1 and 3 has regretted the proposal regarding withdrawal of condition imposed in regularization of service in respect of the petitioner. And also challenge the letter, no, challenge the condition number 2 in the order dated 25/4/2018, annexer number 3 issued by the respondent number 3. Respondent number 3. Respondent number 3. Mr. Khan, learned counsel for the petitioner, submits that the petitioner was appointed as where you have rendered your service.
Lala College, Hailakandi.
He was serving as a lecturer in Persian department in Lala Rural College, Lala in Hailakandi, against a non-sanctioned post. Since 18/8/1999, and his service was regularized by an order dated 25/4/2018. Annexer number 3, with a condition that he has to qualify NET/SLET/PhD within 2 years from the date of joining subsequent to the order. And till then, he will get fixed pay. And thereafter, the petitioner has completed his PhD degree in the year on which date you have obtained your PhD degree?
My lord, on 2/7/2024, page 42.
2/7/2024.
Yes.
2024. And thereafter, he filed an application for granting him regular scale of pay, but the same was regretted by the respondent authority on the ground that he failed to complete his PhD degree within the stipulated period of 2 years as indicated in the annexure number 3. Then being aggrieved, the petitioner approached this court by filing the present petition. Mr. Towilder learned, standing counsel for the respondent number 1 and 3 submits that at this stage, notice may be issued to the respondent. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that notice be issued to the respondents, returnable in 4 weeks. However, no formal notice is required to be issued since all the respondents are represented by their engaged counsel. But extra requisite copy of the petition be furnished to them during the course of the day. List the matter after 4 weeks. This regulation you may keep with you or will keep it with record.
Yes, your lordship. Obliged.
Query number 5.
May I please the lordship. My lord, my minor children, my lord, that birth certificate was not issued despite of my approach, my lord. They are calling me one on the other, my lord. But as per the act and rule, my lord, I need to have issue, my lord. I have quoted the relevant portion of the law at page 9, my lord. There are 12.
No, whether this Universal Knowledge Park School is a private school or
It's
a government
private school, my lord. It's a private school established under act, my lord. They have to take recognition, permission, my lord. Section 4, my lord. All the private school whatsoever, they cannot establish school, my lord, as per the section 4. Assam Non-Government Education Institute Regulation and Management Act 2006, my lord. Lordship can have a look, my lord. I hope. It is negative.
Assam?
This book, my lord, and that book I have not seen, my lord. There I have quoted, my lord. Any school, my lord, private or whatsoever, section 4, my lord, for establishment of the school, and particular act is there, my lord. Right of Children to Free and Compulsory Education Act 2009. Section has not been violated, section has been violated, my lord. So I have no option, my lord. And civil court, I cannot go by virtue of section 27. There is 27 is also there.
But against private school or red petition is
No, my
not
lord,
in the
I am not, I have come for violation of my fundamental rights. Civil court bar, where shall I go, my lord?
No,
Because-
whether no, Mr. Bormuya, whether
Yes, my
right to
lord.
transfer is a fundamental right.
It's a fundamental right. Right to education, my lord, is a compulsory, is a part of fundamental right, my lord. Right to education, my
No,
lord.
no, right to education is all right, but the right to transfer is a fundamental right. You satisfy this court?
This the particular act says, my lord. Act says, my lord, para 9 be seen, my lord. Para page 9, I have reproduced the section, my lord. Section 5. In the book is also there, lordship. Kindly have a look. May I read, my lord? Whereas school there is no provision for completion of elementary education, a child shall have a right to seek transfer of the school, excluding the school specified so and so. Where the child is required to move from one school to another, either by the state or otherwise, the reason such child have a right to seek transfer to any other school, excluding the school specified so and so for seek admission in other school. The head teacher or in charge of the school where the child was last admitted shall have immediately issue the transfer certificate. Provided that the delay processing transfer certificate shall not be ground for either delaying or denying. And basic fact, my lord, some particular code is there, my lord, against the name of the student, and it has to go along with that. Maybe for the reason, and I have given, my lord, and there asking, my lord, I have given a legal notice also, my lord. They are, instead, my lord, they are otherwise, my lord. Language of the note, reply language, my lord, is not a mark of satisfactory, my lord. Page 25 operative part, my lord. Language is something different, my lord. School should not have this type of language, my lord. Last para, my lord, failing which my client will be constrained to initiate a appropriate civil and criminal against you for the competent court, including the actions of the defamation, disturbance, harassment as the sole risks and concerns so and so. It pertinent to mention here that the my client said the school is always willing to cooperate with your client. And page 19, my lord, I have duly approached them. And I have complained again to the inspector of school also. Page 19, my lord. Is sitting over, my lord. It about আছে all the picture will be clear, my lord, from page 19. Page 19, my lord, I, Bilal Hussain, bona fide resident of so and so ward number, to draw your attention that the fact that my son so and so class 3, my daughter so and so student of LPG, it is worth mention here that I permanently settle in the resident of Kajana with my above children at Silchar, for which I have submitted transfer application of my above children before the above said school on the ground of change of my resident. But the concerned principal BC so and so, who demanded the follow TC rupees 3,000 only and perform along with the price of class 3 and 4 Khata, and also refunded 3,000 plus 3,006 as succession session fees. Well, I was admitted my children, if I have still above the demand, and you will award the certificate. And my lord, basically, my lord, my fundamental right granted under Article 21 and particular act, my lord, has been violated. For which, my lord, I have no option by virtue of the section 27 of some non-government, no civil code, nothing. So now no option is left out except knocking the door of this honorable.
Yes, so who is appearing for the respondent?
For the respond of 112 board. In this case, Lordship, except some regulatory measure, we have except some regulatory measure, Lordship, in the anti function others. Otherwise, we have no any partnership control over that respondent school. So that is spiritual. This form is not maintainable, Lordship.
My lord, there is, my lord, order was passed, my lord, 2-3 days before, my lord. They have to get registered for management and administration.
Yes, Lordship, it is correct that he has to register his take permission, but it does not mean to break the 226 of the jurisdiction, and this is not maintainable. Lordship, in this case, Lordship,
Why inspector school is not taking action, my lord?
you have not.
I have annexed. Page 19, I have annexed.
Private dispute between the two
Not
parties.
private dispute, my lord, fundamental rights, my lord.
Is that payment of fees, non-payment, how a inspector will jump over that matter?
It is the authority. He has to look after, my lord, what is the evidence?
Mr. Bormuya, let us fix a short date.
Last
We will hear on the point of maintainability. Let him come prepared, and you produce that PIL, you have told that.
Yes, PL I can give right now also, my lord. Anyway, I'll give.
Heard Mr. Bormuya, Lord.
My lord, what I want, my lord, since the livelihood of my children, my lord, careers, all
We
kids,
will fix a very
Lord,
short date.
my lord, what I want, my lord, please let them take instruction. Why Transport certificate has not been issued. Only that much will serve, my lord. If it is issued or given to me, my lord, no purpose of proceeding, my lord.
No, that's all right, but the question is whether the inspector can be directed to obtain such a
My
inspection.
lord, I made a complaint, my lord. He has to see yes, no, something has to pass, my lord. He cannot sit over just like mere spectator. He cannot, my lord. Page
No,
19, he has to act upon.
No, that's all right, but he must have some control over the private institution.
My lord, private institution lordship would see section 27 says bar, my lord. The book, my lord, of 2020, 2006, my lord. Lordship kindly turned, my lord, for
Okay,
confirmation of the
anyway,
court.
Mr. Dotto, you obtain instruction as to what action he had taken upon the representation filed by the petitioner.
And dice code is issued by the government, my lord. The direct control. All student, my lord, against the name nowadays.
He is correct from his point of view, but my point of view is that this restriction is not maintainable, and without maintaining, not maintainable, not maintaining a restriction.
My lord,
No direction.
my lord, let me read, my lord, section 27.
No, not necessarily, let him go.
My lord,
On
one
the
second,
next
my
date,
lord.
we will see.
For his confirmation, my lord, let only allow me, my
I
lord.
am comfortable with him. I am
Just jurisdiction of civil court barred, except and expressly provided in the act, no decision or order made in the exercise of power conferred by
No,
or under provisions
Mr.
of the act shall
Mr.
be
Barbuya.
questioned in any civil court. No
Let him obtain instruction from the inspector.
Yes, my lord.
whether
Let
any
him
action
take
is
instruction
initiated.
from the inspector of school, my lord. That will serve my purpose.
in 2023, 4 and 6. In January, case of the Supreme Court has cleared that there is no it is maintainable against the private institution.
No, I'm not.
Yes,
Okay.
so
That's at this stage. Against the job or anything. That is against the job. This is, my lord, fundamental rights. My ward, children, my lord. 3 years.
without clarifying his the position of maintainability, lordship may not direct us to take instruction.
No.
Otherwise, what
You-
will
you-
happen, lordship?
no,
after
no,
getting the notice, the inspector
Mr.
will issue
Dutta,
notice, lordship.
You see, here the question of right to education is involved.
I understand. But
Section 5, my lord, clearly says.
Therefore, you are only required to obtain instruction in respect of this representation filed by the petitioner,
Yes.
not otherwise. You could have liked to. The petitioner herein is aggrieved for non-issuance of transfer certificate by the respondent number 5. The principal, Universal Knowledge Park School, Siriwa, Madhurban Silsor, wherein the son of the petitioner is pursuing studies in which class?
My lord,
In which class?
son is, my lord, class 3
Class 3.
and one LKG, my lord. Daughter is LKG. Son is class 3 pass and daughter is LKG. Because nowadays no
The
fail
sons
system.
and daughters of the petitioner are pursuing studies in class 3 and class
LKG,
LKG.
kindergarten, lower kindergarten.
While keeping the question of maintainability of the petition open, it is provided that Mr. Dotto, learned standing counsel for the respondent number 1,
Then miss to service matter.
2, 1, 2, and 4 shall obtain instruction from respondent number 4 as to whether he had initiated any action on the representation filed by the petitioner to him on 10/9/2025.
If any, he will submit it.
If any, list the matter
I have submitted legal notice will say, my lord.
No,
On-
against the
27. 27 November.
My lord. My lord, only one thing, my lord, pendency of the case shall not be barred for issuance of.
Okay.
That order will
Pendency
have to
of
give, my
the
lord, otherwise.
petition. However, it is being clarified that pendency of the petition will not be a bar in issuing the transfer certificate of the petitioner by the respondent number
Five, Lordship.
My lord, in this case, my lord, some development have taken place, my lord.
Okay,
So may I pray that this matter be taken on the first week of December, my lord?
first week of December. The learned counsel for the petitioner, namely your name, please.
A Hassan.
A. Hassan submits that after filing of this petition, some subsequent development has taken place and he will obtain necessary instruction and he tries for listing the matter in the first week of December. Parallel, SSL list the matter in the first week of December.
Or can it be on third of December if possible? Third.
List the matter on 3rd of December.
Item 7.
Maybe. Well, in this case, the petitioners, my lord, are claiming that they are entitled to, my lord, OPS system of, my lord, pension. Pensionary benefit under the, my lord, OPS is old pension scheme, my lord. Now, my lord, in similar cases, my lord, notice has been issued and they were directed. Because, my lord, in the meantime, my lord, the government has also framed a policy, my lord, that the persons who were appointed after 1/2/2005, my lord, but they are entitled to new policy, my lord. But the persons who were appointed, whose appointment process has started prior to 1/2/2005, my lord, they are entitled to, they can claim, my lord, old pension scheme, my lord. So here, my lord, all the petitions have been appointed prior to 1/2/2005. So they are entitled to, my lord, the old pension scheme.
Mr. Das?
Their appointment is actually in the year 2040. Effect from 2030.
Their services were regularized in the year 2014.
Effect from 1/1/2030.
1/1/2013.
The staff of the following professional class. That is page 37.
But their date of joining is long
Yes,
back.
yes,
The year 1996, 98.
Pension stage, madam. Their services were regularized. It from 1/1/2013.
Heard Mr. Jesse Gore, learned counsel for the petitioner, and also heard Mr. S. Das, learned standing counsel for the respondent number 1 and 3, Mr. Solia for respondent number 2. Respondent number 2. In this petition under Article 226 of the Constitution of India, the petitioner is applied for issuing direction to the respondent authorities to allow pensionary benefit to them under the old pension scheme. Mr. Gore, learned counsel for the petitioner, submits that the petitioners were appointed in the year 1996 and 97 and 98 respectively, and their services were provincialized in the year 2014.
That notification, there is undertaking also that then we governed by the new pension system. 10 years after.
Mr. Solia, we are not hearing the matter. Today it is the motion. 2014. But they have been given the pensionary benefit, pension and pensionary benefit under the new pension scheme. Mr. Gore further submits that in connection with the same subject matter, another writ petition being WPC number?
My lord, 5588.
55?
5588 of 25.
25. And in the said petition, notice was issued. Notice was issued. And in this case also, notice may be issued to the respondent authorities. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that notice be issued to the respondents returnable in 4 weeks. But no formal notice is required to be issued since all the respondents are represented by their respective standing counsel. However, extra requisite copy of the petition will be furnished to them during the course of the day. List the matter after 4 weeks. And rest shall take this writ petition along with WPC number so and so so and so.
My lord, the government has also directed the schools, my lord, to prepare a list of such teachers, my lord. So the pendency of this writ petition may not be a bar to if the schools prepare the list of.
However, it is being clarified that pendency of this writ petition will not be a bar in extending the benefit to the petitioners.
May I be so? My lord, the area proposal, area salary proposal has been submitted by the authority, but it has not been sanctioned, my lord, as on date. With amount is 1,67,658 for the period 1/9/2023 to 29/2/2024. So my humble submission, my lord, let the take instruction, my lord, regarding the status.
No, to whom the proposal was submitted?
My lord, it was, your lordship will find in the last page number 27. 26, your lordship kindly take. By the district officer to the director, my lord.
Okay. Heard Mr. Purkeso, learned counsel for the petitioner, Mr. Fukan for the respondent in Elementary Education Department. 1
to 5.
1 to 5. 1 to 5, Mr. Soliha for respondent number 6.
And 7.
6 and 7. Mr. Purkeso, learned counsel for the petitioner submits that while the petitioner was serving as assistant teacher in Bamuni ME School under the Rupohi Education Block, he was placed under suspension by order dated 11/10/2023. And subsequently, he was reinstated on 30/8/2024 and posted at Ansolik ME School under the DI of School Nagaon. Mr. Purkeso further submits that the grievance of the petitioner is that the period of suspension of the petitioner has been regularized, but the area salary for the period 1/9/2023 to 29/2/2024 amounting rupees 1,67,658 rupees has not yet been paid. Though the district elementary education officer has forwarded the proposal to the director of elementary education, Kailipara, Guwahati, by his letter dated 4/9/2025. In that way of the matter, it is provided that Mr. Fukan shall obtain up-to-date instruction in respect of the letter dated 4/9/2025 and apprise this court on next step. List the matter on.
On 5th December.
5th of December.
At the time.
May I please, sir? There is an application for complaint. Not application, petitioner husband was died as an grade 4 employee posted in Goreswar HS School. He died on 27/05/2022, and petitioner preferred an application for appointment on compensatory ground on 07/07/2020.
When you have filed the application?
07/07/2022.
7/7/2022.
2022. Notice may be issued.
No, whether your case was placed before the district level committee.
No, it was received, but it was not sent forward.
Yes, who will obtain instruction?
No, notice may be.
BTC.
BTC lot, otherwise the matter. Here and one more thing also, please, the director of BTC is
Not a party.
not a party here. First, he has to make the director of BTC party. And secondly, lordship, that.
But the inspector of school is a party here.
Inspector of school is a party, but the authority is the director, president, council, they have their own setup. So director office is there. Everything is to be dealt by the director. And the prayer of the petitioner is for compassionate appointment. Now the petitioner, the expired husband of the petitioner expired 27/5/2022. After 31/3/2017, there is no compassionate appointment now. Subsequently, they have the compassionate family pension is there. It also there.
Are you receiving the family pension?
Compassionate appointment.
I'm not aware.
Not aware.
He has to apply for, not for the compassionate appointment, compassionate family pension.
That's it. What happened, this OM is
Moreover, this
issued
point should
on,
be clarified by the BTC director.
No, that's all right. But are you receiving the compassionate family pension?
not aware.
Not aware.
Notice may be issued.
Heard, Mr.
Take only.
Learned Counsel for the petitioner, Mr. P.N. Sharma, Learned Standing Counsel for the respondent number 1 and 2.
1 and 2.
1 and 2. Ms. Bora for 3. 3 and 4. And Ms. Fokon for respondent number 5. Respondent number 5. The grievance being sought to be addressed in this petition is that the husband of the petitioner was working as grade 4 employee who died in harness on 27/5/2022 while he was in service. After the death of her husband, the petitioner, being Praveen within bracket Hindi HS in the year 2007, has applied for being appointed on compassionate ground, but her application has neither been placed before the district scrutiny committee or the state level scrutiny committee till date. Being aggrieved, the petitioner approached this court by filing the present petition. Mr. Sharma, Learned Standing Counsel for the respondent number 1 and 2, submits that the petitioner has not arrived the Director of Education BTC as party in this proceeding, and in order to adjudicate the dispute in this petition, the said director has to be arrived as a party in this proceeding. Then accordingly, he submits that the petitioner may be directed to implicate the director as party in this proceeding. Let notice be issued to the respondents, returnable in 4 weeks. However, no formal notice is required to be issued to the respondent number 1, 2, 3, 4, and 5. Since all are represented by their standing counsel, however, extra requisite copy of the petition be furnished to them during the course of the day. In the meantime, the petitioner shall take necessary step to implead the respondent, implead the Director of Education BTC as a respondent number 6 in this rate proceeding. On next returnable date, the learned standing counsel for the BTC shall obtain instruction as to whether the application filed by the petitioner was placed before the DLC stroke SLC or not. List according. Lovely.
Remember 45.
I have received my instruction as well as whereas given, I want to file an affidavit in the figure. Recruitment is already over. Some affidavit in this.
Okay.
Lordship, there is vacancy, Lordship. Government, one after another recruitment drive is going on, Lordship. One post may be vacant, Lordship, till then. Till disposal, Lordship.
Recruitment for this is already over. I have received the instruction. My affidavit. So they will finally conclude. Nothing will happen.
And backlog vacancy also arrived, Lordship. Many candidates will not be joined. Appointment has been distributed.
Presently, at this moment, we cannot say.
No, no,
I am
if-
qualified,
if-
Lordship.
No, if vacancy is there, we may consider your pair on next date also.
Yes.
Let him file his affidavit.
Right now, nothing will happen.
Even yesterday, I think some appointment has been given, Lordship.
No, they have got 15 days windows to join, so they are joining lawsuits on a selected candidates.
No, yesterday, I think in lower primary school, Lordship, 98 appointment was given, Lordship. I have personally seen in the newspaper, Lordship,
That
advertisement.
doesn't give you any right or legitimate right to claim that appointment. Let me file my affidavit, I will explain what is there.
No, Mr. Sisti, you see, the petitioner has secured more mark than the other candidates.
That is all right. That is not a criteria for which we have rejected. Because he is a diploma holder of NIOS, 18-month diploma holder. National Institute of Open School Lawsuits, that 18-month diploma holder. So that diploma holder initially, just we have hold that they were not eligible. I think the Supreme Court, it was case gone to the Supreme Court said that they are eligible. Only with a condition that they have to be in service prior to 2017 and they have to obtain that qualification between 31 or more to 2019. And for that, Honorable Supreme Court has said that you have to verify, you have to, after only verification, if the entitlement is there, only they can be appointed or selected. So we have allowed them to participate. Now, as per the Honorable Supreme Court, we have issued a notification. We have given them a list of 6 documents for verification. They have to produce those. They failed to produce that document. I'll submit
As per
everything.
my
with
information,
records
I have
of it.
produced everything and annexed also in this petition also, Lordship.
I have all the instructions. Even his name is not, Lordship, the discrepancy in his name in the board of admit card as well as in the. I have submitted everything, Lordship. It's not that only the customer.
Okay.
Yes.
Heard Mr. Soduri, learned counsel for the petitioner, Mr. SMT Sisti, learned standing counsel for the respondent number 1, 2, and 5. And Ms. Popon for respondent number 4. Respondent number 4, Mr. Sisti submits that he has received instruction and he will bring on record the said instruction by filing an affidavit. And he tries for granting 1 week time. 1 week time, pair allowed, recess and list the matter on. Sort that.
4 December.
4th of December.
Items for admission. Item number 11 to 15. Alternate.
My lord had directed me to look on certain judgments, my lord. That might overcome the barriers of section 24 of the act. My lord, in that sense, my lord, ordinance judgments, but that will be relevant.
No, you have not given the list.
My lord.
You have not given the list of the decision.
No, my lord, I have bought the decisions from the library, my lord. And this is Confederation of Ex-Servicemen, Associations and others, my lord, page 399. If your lordship may kindly come to paragraph 33. Paragraph 33, my lord, at page 416.
Yes.
We are also not impressed by the argument that all medical benefits and facilities must be provided to ex-servicemen under the doctrine of legitimate expectation, my lord. This judgment is on legitimate expectations, my lord. The doctrine of legitimate expectation is the latest recruit to a long list of concepts fashioned by the court for review of administrative actions. No doubt, the doctrine has an important place in the development of administrative law and particularly law relating to judicial review. Under the said doctrine, a person may have reasonable or legitimate expectation of being treated in a certain way by an administrative authority, even though he has no right in law to receive the benefit. In such a situation, if a decision is taken by an administrative authority adversely affecting his interests, he may have justifiable grievance in the light of the fact of continuous receipt of the benefit, legitimate expectation to receive the benefit or privilege, which he has enjoyed all throughout. Such expectation may arise either from the express promise or from consistent practice with which the applicant may reasonably expect to continue. 34. The expression legitimate expectation appears to have been originated by Lord Denning, MR, in the leading decision of Smith versus Secretary of State, in Attorney General of Hong Kong versus NG Yuan Shu. Lord Fraser, referring to Smith, stated, the expectations may be based on some statement or undertaking by or on behalf of the public authority, which has the duty of making the decision. If the authority has, through its officers, acted in a way that would make it unfair or inconsistent with good administration for him to be denied such.
So, Mr. Sharma,
my lord,
your entire argument is confined to this doctrine, legitimate
expectation
Is it?
and right to equality, my lord. I have bought in 2 additional judgments also on equality, my lord. Those are the facts have been submitted, my lord, in elaborate detail before this honorable court. My lord had raised a query that since I was provincialized under the 11 Act, and the 11 Act was subsequently repealed, and thereafter the 17 Act.
Let us do one thing.
My lord.
In connection with another similar matter, we have got some decisions recently, yesterday.
My lord.
I am giving the list to you.
My lord.
Regarding retrospective effect of the legislation.
Legislation, my lord.
Because in the section 24, it is stated that
yes, my lord.
Since the earlier act has been repealed,
yes.
So the teachers appointed under the said act will be governed by
This
the
act.
present act and other matters also.
My lord.
But the decision speaks otherwise.
Yes.
I am giving the list to you.
Yes, my lord.
Right now.
Yes, my lord.
You go through the same.
My lord.
You come prepared.
My lord. My lord.
So apart from this doctrine of legitimate expectation,
My lord.
we will see the other decision also.
Absolutely, my lord. I'll be grateful, my lord. In fact, I have also traced certain judgments, my lord, based on Article 14. In fact, judgments to apply specifically on the facts of the case because the facts are slightly peculiar, my lord. I have not found judgments to include facts which are submitted before this honorable court in this matter. But there is a judgment, my lord, where E.P. Royappa, where Justice Bhagavati spoke in detail as to what Article 14 would entail. and whether Article 14 is merely a constitutional right and also is it a political right as well. So the entire aspect has been defined, but those are very general indications of this honorable court as to the applicability of Article 14. Article 14 cannot be violated, that's a fact, but the other issue which has arisen is that my rights have subsequently arisen, my lord. And 97 to affect it to Royal Powers. 1974 4SC.
So Sharma, you see, there are several decisions. These decisions were referred in another matter.
My lord.
You go through these decisions.
My lord.
This may help you.
Yes, yes, my lord.
Study. So let us fix the matter on Monday or Tuesday.
Yes, my lord. My senior friend might have.
Monday I have.
Tuesday, Wednesday, Tuesday, Tuesday,
Tuesday, my lord.
So this decision you are referring to in connection with this
My lord.
74?
My lord, in the 74, my lord, what is the ambit of Article 14? If your lordship may kindly come to page 30, paragraph 85.
Paragraph?
85. Paragraph 85, my lord. The last two grounds of challenge may be taken up together for consideration.
No, this State of Tamil Nadu and others. The second decision.
My lord, State of Tamil Nadu and others, my lord. What is the question? Yes, my lord.
Part Mr. M. Sharma, learned counsel for the petitioner, Mr. Talukdar for the respondent in Elementary Education Department, Ms. Bora for BTC, and Ms. Fokon for respondent number 1. Heard in part, list the matter for further consideration on Tuesday.
Tuesday, my lord.
Tuesday.
Thank you.
এইটো নহয় দৃশ্যটো
What numbers? 15 to 20.
সেইটো adjournment.
Item 22.
Lordship. Timing.
Timing. Does-
23 and
does-
20. 23 and
Mr.
24.
Sharma, you take back this book, produce it on Tuesday.
Lordship 23 and 23 for the time being, my lord.
Timing.
The answer.
I don't, otherwise, my lord, I will take some recommendation. Or
Let him come. He is on code number 10, my lord. That is.
Okay, let him come.
Item 25. 25.
It went 23 kiva. নহয় 22 to okay.
Item 25.
Mr. Fukan, where is the petitioner? You do not know. Then I press for the petitioner on call. How about Mr. A. Fukan, learned? Huh? Then I press for the petitioner on call. How about Mr. Fukan, learned standing counsel for the respondent in elementary education department present. Office note dated 18/11/2025 indicates that the petitioner has not filed the amended cost title for which the name of respondent number 5 could not be incorporated in the cost title as well as in the CIS. Leaves the matter after 1 week. In the event of subsequent non-representation of the petitioner, appropriate order shall follow.
Item 26.
Correct. Agar.
May I please? Lord, the middle school teachers, my lord, they have their science graduate middle school teachers. They have, my lord, procured the certificate on in primary education.
Mr. Professor, Mr. Khatonier is supposed to appear here.
Yes, sir, they are, my lord.
Mr. Fukan?
কোন থাকে বল? আজি কার কলার থেকে? মাত্র দেখুন 26.
Doctor will have it up sometime, Mr. NJ Khatuniya is in the second.
Item 27.
Lord, here in this case, my lord, my friend was asked to produce the individual information of the private respondent. My lord.
The department could not find out the document, the SLC recommendation of the private respondent. Kindly give me for 2 weeks time, madam.
2 weeks time. No, only for production of that document.
Yes, madam. Otherwise, my lord has hard time, madam.
Uh-huh.
Only thing is the SLC recommendation of the private respondents.
Because
Wait, so we'll grant a 1 week time you produce the document. Well, heard, Mr. Sector Learned Counsel for the petitioner, Mr. S. Das Learned Standing Counsel for the respondent in Higher Education Department, Mr. Abedin for respondent number
7.
7 and 8, and Ms. Fokon for P and 4. Mr. Das submits that he may be granted 1 week time to produce the recommendation of the SLC concerning the private respondents. Here allowed, or is this a less the matter on
28.
28?
20. No.
Otherwise, hearing is concluded.
Item number 28. Okay.
None appears for the petitioner on call. Mr. Abedin, you are here?
No.
None appears for the respondent also on call. This is the matter after 1 week in the event of subsequent non-representation of the petitioner as well as respondents, appropriate order shall follow.
31.
May I plead your lordship? The matter pertains to the provincialization of service of the petitioner as Sanskrit teacher. When the matter come on 30/10/2025, the court directed the respondent to file an affidavit why the petitioner is left out in 2013, my lord, although he was duly recommended by the committee, my lord. And that affidavit is not filed today. And lordship kindly peruse the last order, my lord. 31/10.
Who will file the affidavit?
The
Respondent number?
Respondent number 3.
Respondent number
He
3.
was left out in 2013, although he was duly conformity with the rules, my lord. And thereafter, in 2007, they have filed an affidavit, but that only mentioned that why he was left out under 2017 Act. And that affidavit is essential. And
Anybody for the secondary education? Okay.
Yes, kindly pass over this matter for the time being.
Who will appear?
Sir?
Who will appear? Who will appear?
My senior lordship,
Who is your senior?
K. Borwa lordship.
Okay.
In this case, affidavit has not been filed by the last occasion they have also sought time manner.
Heard Mr.
As Sharma, my lord.
S. Sharma, learned counsel for the petitioner, and also heard Miss learned counsel for the respondent. Learned standing counsel for the respondent number Dibrugarh University. For the respondent number 1, 2, 3, and Ms. Fokon for 4. The learned counsel, standing counsel for the respondent number 1, 2, and 3, pays for granting 2 weeks time to file the affidavit in opposition.
A date may be given, my lord.
There is allowed recess unless the matter on
15 December.
15 December. it is clarified that no further chance will be granted to the respondent number 1, 2, and 3 to file their affidavit in opposition.
Deeply obliged, my lord.
Item 34. Item 34.
None appears for the petitioner on call. Also, none appears for the respondent on call. This is the matter after. You are for BTC, Ms. Bora for BTC, present. List the matter after 1 week in the event of subsequent non-representation of the petitioner, appropriate order shall follow.
Item 46. Department Mayor.
Thank you, Lordship. Lordship, in this matter, the secretary has directed the Director of Elementary Education Department to conduct a hearing on 8th of December, Lordship.
On?
For the details, because apparently Lordship, admittedly Lordship, the petitioner who is not rendering service from 2014. That my learned friend has also confirmed that criteria why the petitioner was not accommodated. So that Lordship will find in the affidavit in reply filed by my learned friend. Where it has been stated, Lordship may kindly page number 54. On 8th, there is a hearing conducted. Asking for the details, so because that continuation in service of the petitioner is continuing. One of the criteria. I believe if it's the matter after 8, we'll have some complete instruction.
You received the copy?
No. But before I receive the copy, is it possible, my lord, when the matter is part heard, its complete hearing, when the matter is in session of this honorable court, can a hearing, a departmental hearing take place at this stage unless and until this court gives a direction asking them to go for a hearing? I don't know. I never heard this, my lord.
Ascertain the actual fact, Lordship, because Lordship may kindly
Nothing to ascertain. Everything is before my lord.
Affidavit in reply filed by my learned friend at page number 50.
No, that's all right.
Page
Says,
number 54, may I read out?
no, since 2014 says,
Admittedly, he is not going to school. Admittedly, Lordship, it has been admitted by the petitioner.
no.
That
If
the
she was,
petitioner continued to go to school till December 2014.
Mr.
thereafter
Sharma.
the Petitioner stopped going to school. This.
No. On the other day, Mr. Abedin has submitted before the court that she is no longer in service as she was compelled to hand over the charge of the headmistress to another person.
That is the version of the petitioner, Lordship. That is the one-sided version of the petitioner.
That is not one-sided, your order.
Lordship.
My lord, this kind of.
Lordship, otherwise also the hearing is taking place, Lordship, because Lordship accommodates something to be in December, Lordship. Let the facts come out, Lordship. Because as for the because he was not in service after 2014. So let that facts be ascertained by conducting a hearing. The direction is there from the secretary. The Lordship direction to ascertain.
No, the legal position is whenever this court is insisting of the matter, you cannot consider such kind of hearing, conduct such kind of hearing without leave of the court. Without leave of the court.
My lord, only one thing, if your lordship permits, my lord, I will take 1 minute. Because of the division bench order, you form the screening committee. You take 4 years for the screening committee to complete the screening in respect of 5 zones. After that screening committee was over, you get together everything. Then you place the matter before the cabinet. You form a cabinet memorandum, you place it before the cabinet. Cabinet approves it.
then you go for the, it is not that you have not made any regularization, you made regularization. When I approached this honorable court saying this is the criteria they laid down, I fall within the criteria. Why I was not given only 2, 3 words? His case is not approved. Why? This was the exact, my lord remembers this, that was put forward. When he meets 2007 cutoff, he has got the salary, she has got the salary till 2012. She passed junior JBT training. You started 2012, I passed JBT training before that, 2011. You sent me for deputation to get that JBT training done. And now at this stage, when the matter is complete, your lordship only wanted to see one thing. Why? At that stage, can a hearing be taken place by them in the departmental? When the,
Mr. Abedin, let them verify the facts again. And but you should not take any decision without leave of the court in either way. And you also informed that they are not entitled to conduct such kind of hearing without leave of the court. No, I will not make any observation in this whole proceeding. But what they can legally do, they cannot do the same illegally. You inform them. Okay, let it be on 10th of December then.
After 15th, perhaps 8th is the date, so one
Yes.
time after.
let it be on 12th, my lord.
One
That will be
week
fair.
8th is the date and 1 week thereafter, also, anyway.
No, 12, let it be 12,
Loss.
Friday.
Yes, my lord.
Heard Mr. Abedin, learned counsel for the petitioner. And also heard Mr. Sarma, learned standing counsel for the respondent in elementary education department. Notably, Mr. Sarma was directed by order dated 14/11/2025 to apprise this court to obtain written instruction as to what are the criteria which the petitioner did not meet during the screening conducted by the screening committee, and to place the same before this court. Mr. Sarma submits that. Thereafter, the Joint Secretary to the Gopta Assam Department of School Education has fixed 8/12/2025 to conduct a hearing on the said point, and he pays for listing the matter after a week. There is accordingly allowed list the matter on 12th of December 2024 or 2025. The letter produced before the court today shall be marked as annexure A and be taken to the record. Will not grant you further time. Recess shall list the matter as parted.
Deeply obliged, ma'am.
Your lordship, I'm very sorry, so in the last item, in item 34, lordship. I could not appear in time, lordship.
What to do?
Sir, my presence may be shown in this case, your lordship.
Okay. Later on, Mr. Your good name,
Yes,
please?
yes, Royal Lordship.
Yes, Roy, learned counsel for the petitioner, entered appearance. Next.
Much obliged, Lordship.
Item 47.
May I please look? Lordship, may kindly see the last order, 12/11.
The petitioner pension has not been regularized in spite of the fact that he was retired in the year 2017.
Yes,
Mr. B.
anybody-
Kaushik,
Elementary Education Department?
yes, my lord, Mr. B. Kaushik was supposed to elementary education. The Department of Elementary Education by letter dated 7/2/2023 at Annexure 30, my lord, page 49. It was communicated to the Office of the Director of Pension that the withdrawal was not is not attributable to any misrepresentation on the part of the petitioner, my lord. The pay fixation was wrongly, my lord, done, my lord.
The G Pegu is appearing in this matter. Can this matter be taken up at 2 PM?
Pegu.
Last occasion, Mr. Kaushik, he was supposed to the instruction. His name has been reflected in the cognizance.
She might not even believe it, but Mr. Ganesh Pegu is allowed to do. So he's the very good.
Okay.
Yeah,
My
2
lord.
PM.
Timing.
Not 2 PM, timing.
Timing items. Item number 22.
Please, lordship. And this, my lord, case, the petitioner, my lord, is an Arabic teacher, lordship. His name was recommended by the District Scrutiny Committee at page, my lord, 2020, lordship. Page 20, annexure 7. My lord, the relevant is at page 21. The staff recommended by the District Scrutiny Committee, lordship, that is DLC, District Level Scrutiny Committee. My lord, at page 21, lordship, serial number 4, Rafiqul Islam, Arabic teacher, lordship. But while my lord, provincial election, the service of the, my lord, teachers, lordship.
Elementary Education. Elementary.
His name was dropped out, lordship. Now, in the honorable division bench, my lord, decided the issues, lordship, but that is under review, my lord. In such a case, lordship, circumstances, lordship, this honorable court, my lord, disposed of the similarly situated petitions, lordship. My lord, my submission is in that line, my lord, may be disposed of, lordship. Otherwise, my lord,
It is pending before the division bench.
my lord, division bench, my lord, decided the issue, lordship. That has been under review.
Okay.
Now, my lord,
Review petition is yet
that
to be
situation,
discussed.
my lord, the writ petition, my lord, different writ petitions, lordship, has been, my lord, disposed of, my lord, that is at page 42, lordship. Given. In such a way, my lord, it may be disposed of, lordship, otherwise, my lord, keeping it, my lord, pending, lord. I think also, my lord, Arabic teachers and the Hindi teachers are there, lordship.
Mr. Fuqar?
My lord, Sharma, he is there, my lord. He's on next one and different one.
Ian Sharma?
Ian Sharma, he is there. He's appearing in this matter.
Let him come.
He's
Hello.
next.
Timing 23 and 24.
May I be the lord? So, lordship, this matter is also exactly similar to their item number 46. Although, lordship, the petitioner fulfilled the eligibility criteria as prescribed by the screening committee as well as the advertisement, lordship, of 2012. The service of the petitioner is not regularized or accommodated as a tutor, lordship. But here, lordship, the affidavit is required, lordship, till that they have not filed affidavit. But lordship, some time ago, but it is 2021.
When are you going to file the affidavit?
2020.
First matter, I take the instruction matter, whether
No, this matter is of 2021.
21 matter, let them file affidavit, lordship.
heard Mr. Dekar, learned counsel for the petitioner, Mr. Talukdar, learned standing counsel for the respondent in elementary education department. Mr. Talukdar submits that he may be granted some time to file the affidavit in opposition. Where allowed, recusal is the matter on. Okay. 10th of December.
24 is also similar note.
It appears that this matter is pending since the year 2021. In that view of the matter, Mr. Talukdar is directed to file his affidavit without fail by next day. This 23 and 24 are tag matter.
Tag matter.
Okay.
Highly obliged.
Coming item 26.
Whether we could take away 2 minus and they have to make it clear matter.
Oh.
And
But we have no matters till 2 p.m.
after some time, then.
Okay. No, not at all. Monday.
Next month. One matter is going on Monday, for some sites.
Is the focus got? Okay, as agreed by learned advocates about the parties, recusal is the matter on Monday.
24th.
Next matter.
Coming item 21.
Can I say this one? Last for the last auto I asked to file a detailed affidavit in opposition, your Honor, additional affidavit. However, we have not received any instructions on that, your Honor. I just want to face subsequent examples of it. Because the director has written to the inspector of school, your Lordship. From inspector of school, they have not received any detailed report, your Lordship. For which
Item
we
number?
were unable to file a detailed affidavit.
So you furnish a copy of the letter to her.
Lordship.
So this letter was written only on 18th. Why? The order was passed on
Yes,
31st of October.
But even way back, sir.
Heard. Ms. A. Buzar Borwa, learned counsel for the petitioner, and Ms. D. Musahari, learned standing counsel for the respondent in secondary education department. Ms. Borwa for finance department. Respondent number 2. Ms. Musahari submits that though by order dated 31/10/2025, she was directed to file a detailed affidavit, but the instructions are still awaited. Though a letter was written by the Director of Secondary Education to the Inspector of School LDC, North Lakhimpur. And the reply to the said letter has not yet been received, and accordingly she submits that she may be granted some more time to file the detailed affidavit. Here allowed, recusal is the matter after 1 week.
Lordship, 2 weeks.
Lordship, my lord, date may be fixed on 11 December.
11. Okay, 11. 11 December. The letter produced before the court today shall be marked as annexure X and be tagged with the record.
Something item 32.
You could kindly fix the matter at two lots.
Pardon?
Fix that two lordship.
No. After some time, I'll let him inform.
Item number 55 for orders.
May I please, your lordship? My lord, on the last occasion, I prayed your lordship to grant me some time to go through the hearing report, my lord. I have gone through the hearing report, my lord. This is completely, my lord, against, contrary to what is, my lord, directed in the order of the petition, my lord. My lord, kindly see the order. Is 2829 relevant, my lord? It is the government, my lord. Secretary Appellate Authority, being Appellate Authority, he has to, my lord, conduct the hearing and he has to pass the order, my lord. It's 2829, my lord. It's 2829, my lord, relevant last portion. My lord, may I read, my lord? Page 28. From the middle, my lord. After hearing the learned counsel for the parties and considering the entire aspect of the matter, the petitioner is directed to prepare an appeal before the Secretary Department of School Education on or before 31st/1/2023, along with a certified copy of this order with his memo of appeal and the relevant documents, obtaining necessary acknowledgement from the said authority in that regard. In the event of filing such appeal by the petitioner before the Secretary Department of School Education within the time so specified, the Secretary concerned, after hearing the petitioner, the respondent number 7 and other authorities including the District Elementary Education Officer Gwalpara, and on verification of the relevant records in original, shall dispose of the appeal of the petitioner within a period of 90 days from the date of receipt of such appeal. My lord, this is mainly, my lord, direction part. I will submit appeal before the secretary and secretary has to pass the order within a specified period, my lord. Thereafter, what happens, my lord? 9 times I have appeared, being a lady, my lord, 200 kilometers up and down for 400. For 9 times I appeared before the hearing, my lord. And after that, I am getting award today. Negative order. Final order goes yet to be passed by. This order was passed by the secretary, my lord, and this honorable coordinate bench, my lord, said, no, this is not the order as per the direction of this court. Then thereafter it was withdrawn, my lord. This order passed by the secretary was withdrawn. Just, my lord, this is what is called, my lord, just shifting game. He sends the papers to director, director sends the papers to DEO. This was the order of like Nasser, my lord, and then on a specific query made by the court, my lord, this was withdrawn. Then secretary, my lord, passed an order saying that petitioner is senior and respondent number 7 is junior. I joined in the year 1994 and respondent number 7 joined in the year 1996, my lord, and this was reflected, mentioned in the district scrutiny committee minutes also, my lord. His name was, respondent number 7 name was sent for the post of headmaster, my lord. And my name was.
No. Mr. Mullah, you see, direction was to place the matter, to file the appeal before the secretary.
My lord.
Then the appeal was filed, but it was not disposed of in time.
No, in time, that is different thing. Now that they are coming to the conclusion, what I think, my lord, it will go against me. Then, my lord, this is after cancellation, this order, my lord, has been passed by secretary, saying that I am senior. Now, my lord, where is the occasion, my lord, of passing this order? This is the hearing taken up by the director, my lord, which does not permit, my lord, this honorable court. The order does not permit the director for conducting any hearing, my lord. Where is the occasion and scope of this order, my lord, which is against me, my lord, saying that no, I am junior and respondent number 7 is senior.
My lord, my
No,
petitioner,
no, you see, if the direction was to place the, no, to file an appeal and you have preferred an appeal and the same was disposed of, then the order of this court appears to be complied with.
order has to be complied with, my lord, yet to be complied with. It is not in compliance.
Hmm.
Now it, lordship, whether got it or not. I have
Which
to
order?
detail
That
the
order-
system. This is the hearing order.
Hmm.
My query, my lord, where is the scope and my lord occasion of passing this hearing order after the final hearing taken up by the government? And it is the government to pass over the order, my lord. And my petitioner, my lord, instructs me that secretary, he is saying, my lord, trying to give justice. Secretary says no. Headmaster, there is no headmaster post. He will not give appointment. He will not get appointment. So for the instruction from my client concerned, my lord, government, my lord, he is trying to give justice. But now the last hearing, my lord, beyond jurisdiction, it is against me, my lord. So some
Which one?
observation may kindly
Which
be
one?
given.
Which one?
This last one, my lord. And prior to this, and there is no date also, my lord, of the last hearing. In the director's hearing order, my lord, minutes, there is no date also. No, last one. Last one, no. Government says I am senior, my lord.
No, no. Mr. Ahmed, you see, if you were aggrieved by this order,
My lord.
you challenge it. But if when the direction is to file an appeal and to dispose of the appeal, whether this contempt petition can go on.
No, this is not the final order of suggestion. The director passed the, my lord, some minors suggest, my lord, it is suggestion, my lord, not the final outcome.
Which one? Which one?
My lord, I have handed over 2 copies, my lord.
Yes, which one?
Next one, that is dateless, my lord. Hearing, my lord.
16.8.
One is by the government, my lord, and the other one is, my lord, by the director office. Headline, kindly, my lord, see the headlines. Heading.
So you may challenge this order.
Correct. Final order is yet to come, my lord, by the
No, you
government,
say,
from the government, my lord.
so the claim of the petitioner cannot be considered.
Considered.
So this is the final order. They have finally disposed of your appeal.
But the appeal, my lord, should have been, my lord, disposed of by the government secretary, as per the order, my lord. Beyond jurisdiction, my lord. And that respondent number 7, my lord, 1 year back, he has already retired from the service also, my lord. I deserve it, my lord, being a lady, my lord, I have sacrificed for the school and today I am going to be deprived, despite my name has been forwarded by the district scrutiny committee, my lord, as a senior. Now, how does he becomes senior to me, my lord? I expressed, my lord, my fear before this honorable court that the time is lingering, meaning thereby, my lord, something is going on. He will just make and produce one document. No, this was not brought to the notice at the time of preparing the list of the incumbents. So it was left out, and that will be considered. That has come to, my lord, into reality now. My lord, obviously, when the order is complied wrongly, rightly, we have to approach by way of writ petition again by challenging that, no doubt, my lord. But some trend, my lord, contempt petition, time after time, my lord. Lastly, my lord, XYZ order is passed. People have to, litigants have to approach this at their own cost, my lord. Many sides we have to see, my lord. Being a lady, my lord, second time litigation. Now I have now third time, my lord.
So far as practicable, my lord, things should be, my lord, summed up, my lord, in a nutshell. My lord, order is to be passed. Final order is to be passed by the secretary, my lord, as per the order, and
No.
he is the appellate authority.
No, no. Oh, who is the appellate authority?
Government, my lord.
Yes, Madam, why the final order is not passed by the secretary?
This is the final price.
Which one?
Lordship may peruse section 13, 11, page 126.
13?
13, 11.
Which letter?
No.
Hmm.
Secretary.
Secretary.
No, my lord, this is the minutes of the SLLC, my lord.
Which one?
This property. This just now the petitioner referred the minutes, my lord. Minutes 22.
Hearing.
25.
Hearing report.
Not hearing. Takes like the scrutiny committee, my lord.
No, that was not produced before this court.
No. No, last time. Then, my lord, matter may come up on Wednesday. In the meantime, I will go through this also, my lord. And that day, if necessary, my. No, it is not.
Where is the case of the petitioner?
Second.
Second page.
Start from first, my lord. Go to the second.
No, if the direction was to place the, to file the appeal to the secretary, then the order ought to have been passed by the secretary.
Secretary, my lord.
Let me fix time on the basis of the final matter. Secretary will pass the order, final order matter.
My lord, the order once again may kindly be reflected, my lord. This order, my lord, direction part, the writ petition, my lord, may kindly be reflected. That will act, my lord.
No, actually, we are not concerned with this. We are concerned with filing of appeal and disposing of the same by the appellate authority.
Exactly, exactly, my lord.
Hmm. So why the matter was placed before SLC?
Because matter is thinking and as a
No, direction was to place the appeal, file the appeal, and to dispose of the same by the secretary, appellate authority.
because as per the act, the decision is the final one in regards to the provincial election matters. Section,
No, that is a matter not connected with the litigation. It's a fresh matter, my lord. As per law, appellate authority is the government.
according to the government matter, it is the excellent state level act matters.
Hmm.
And even
No,
then-
as per the act, but what was the direction of this court?
Direction of the
Now, just taking into its compliance order, we have to be. Now, like if you want to tell, locally, the secretary will. The fix not also.
I should not say, my lord, but I am, my lord, deprived in this case, my lord.
Now you are serving as
Assistant teacher, my lord.
assistant.
Assistant
teacher.
teacher.
And the claim is for
Assistant teacher.
assistant teacher,
Language teacher.
language teacher.
as per this report, my petition is junior matter and the respondent number is the senior person.
My lord, the fact is that I should not take a lot of time of this honorable court. My lord, fact is that when respondent number 7 found that there is no post of headmaster, now, my lord, he has come down from the sky. First, he, my lord, wanted the post of headmaster. When he found, not only he, my lord, many other cases also, when they have found, my lord, there is no post of headmaster, now they have come down, my lord, to the ground, my lord. And now they need 80 post, my lord. This is the case, my lord. And how he has made this document, I do not know. He submitted this, my lord,
No,
staff pattern.
Madam, you see, the second page of the SLC resolution, there the date of joining of Nasiruddin Ahmed is shown as 11/6/1996.
It is claiming matter, but as per the record matter.
I am not claiming.
This is claiming matter, as per the record matter, the respondent is appointed on 9/1/1994 matter.
Hmm.
And the petitioner is appointed
2nd of March 1994.
matter, 3/3/1994 matter.
No, here it is written as 2/3/1994.
Yes, 22, my lord.
Okay, Mr. Mullah, you
My
go
lord.
through these minutes.
My lord.
You go through the minute.
No, I have not seen, my lord, this. This is
No,
not.
they will furnish a copy to you. Furnish a copy to
My
him.
lord, my lord.
Heard Mr. Mullah, learned counsel for the petitioner, Ms. Sutia, learned counsel for the complainant. During the course of deliberation, Ms. Sutia has produced one minutes of the meeting of the State Scrutiny Committee regarding court cases filed in respect of provincialization of service under the Assam Education Provincialization of Service of Teachers and Reorganization of Educational Institution Act 2017 in the 17. Mr. Mullah submits that he may be furnished a copy of the aforementioned minutes so that he may obtain necessary instruction in this regard. Accordingly, it is provided that Ms. Sutia shall furnish a copy of the minutes to Mr. Mullah during the course of the day. Further, Ms. Sutia submits that she may be granted 1 week time to produce the findings of the appellate authority. There is accordingly allowed to list the matter after 1 week on
Second,
2nd December.
Deeply obliged, well.
The minutes of the meeting shall be marked as annexure X and they take to the record.
Obliged.
turning item 22 for admission.
Lordship, petition was a Arabic teacher, Lordship, and service of other three provincial Lordship who were far junior to him, Lordship. But
Matter, I would like to find my affidavit. Because the affidavit is, I'm constantly, I've got my instructions today. The affidavit, my lord, is saying that the petitioners are, he's senior to the provincialized. Fact of the matter is that the people who have been provincialized have been, are people who are, given, appointment as per the act, that is as per rule 3(1)11. Which prescribes for one in one language teacher English, one, my lord, one language teacher, one science and mathematics, and one social science. So my lord, will allow me to bring this on record. To take question.
Lordship, I have submitted a similarly situated order, Lordship. It may be disposed of if same order may be passed, Lordship.
But the question is whether your case will be covered by this decision or not.
Lordship.
I'll let him file affidavit.
It may be fixed then. Otherwise,
Heard. Heard, Mr.
I am in Lordship.
I, Ahmed, learned counsel for the petitioner, and Mr. Fokun, learned standing counsel for the respondent in elementary education department. The learned counsel for the petitioner, by producing a decision of a coordinate bench of this court dated 22/10/2025 in WPC number 5072 of 2021 submits that similar order may be passed in the present petition also. However, Mr. Pukon, learned standing counsel for the respondent in elementary education department, has produced one written copy of the instruction, and on the basis of the said instruction, he submits that he may be granted 1 week time to bring on record the said instruction by filing an additional affidavit. By filing an affidavit, fair is allowed. Recessal is the matter after 1 week.
On 4th December.
4th of December.
Like.
Turning item 32 for admission.
My lord. I'm sorry, my lord, I was in another court meeting. My lord, this petition, my lord, pertains to my lord appointment of principal, my lord. Pursuant to an advertisement, my lord, I have my lord participated in the my lord selection process, my lord, and after my lord, after due selection, my lord, the private respondent was my lord appointed as a my lord principal, my lord. Although my lord, I have secured my lord the marks, my lord, if advertisement, my lord, kindly have a look at page 33, my lord, main, my lord.
But who are appearing for the respondents?
My lord, education and BTC is there, my lord.
BTC?
BTC and my lord.
Higher education. You are referring to page number?
I'm referring to page number, my lord, page number 30, my lord, is a, my lord, advertisement, my lord. And the relevant point is at page 33, my lord. Page 33, my lord. Top, my lord, leadership skill, 4 marks. My lord. I'm agreed by this, my lord. Here, my lord, result of SSLC HM examination in case of graduate teacher and SS final examination in case of postgraduate teacher, and petitioner before lordship is a postgraduate teacher, my lord. In the school where he is a teacher, result of proceeding year of selection. Up to 60% 1 mark, 61 to 71% 2 marks, 71 to 80% 3 marks, above 80% 4 marks. And now kindly see, my lord, page 29. The result of proceeding year, my lord. Page 29, my lord. So, my lord, page 29, my lord. It's my lord. It says higher secondary result 2024, my lord. And my school name is, my lord, Gosaigaon SS School. And percentage is, my lord, 87.59. So I should granted 4 marks under this category, my lord. Now, my lord, kindly see, my lord, next, sir. Page 50, page 60, my lord. The my lord. Made list, page 60, my lord. Serial number 8, Bhanumati Burma.
Page number?
Page number 60, my lord.
60.
60, my lord. Page, serial number 8, Bhanumati Burma. She was, she is a, my lord, private respondent, my lord, who was, my lord, appointed as a, my lord, principal of the of my school, my lord. Bhanumati Burma. She secured total marks, my lord, 50, my lord, last, my lord. Total marks secured 50, my lord. And next page, my lord, where my marks is serial number 16, Gosaigaon SS School, Gunindranath Burma is the petitioner, my lord. Here, my lord, 9th column, your lordship will find result of SS and SSLC for last year, 9th column, my lord. I was granted, my lord, 3 marks, my lord. So I should have granted, my lord, 4 marks, my lord, as per the terms of the advertisement, my lord. And ultimately, total, I secured total marks 14, my lord. If I had granted, my lord, eligible marks, my lord, then, my lord, my marks would have, my lord, equal to the marks, my lord, which was, my lord, obtained by, my lord, private respondents. And so far, my lord, seniority is concerned, my lord, I am senior to her, my lord. And now, my lord, kindly see, my lord, date of joining, my lord. Page 61, my lord, my date of joining, my lord, as column number 6. Date of joining as graduate, postgraduate, 10/12/1994. And my lord, my date of birth is, my lord, 01/03/1968. Page 61, my lord. Column number 6 and 7, my lord. My date of joining is 10/12/1994. And my date of birth is, my lord, 01/03/1968. Have a look at what, my lord. Page 61. And page 60, my lord. Her, my lord, date of joining and my lord.
In SS and SSLC and SS examination, in respect of the candidate securing first division, 3 marks is awarded,
Lordship, my lord.
right?
Lordship.
So you have been given the 3 marks.
No, my lord, where, my lord, result is, my lord, result percentage is above 80%, then, my lord, my lord, given, my lord.
Where it is indicated?
33, my lord. Condition of the, my lord, advertisement. Page 33, my lord. leadership skill. Last column, my lord, up to 6, result of SSLC AHM examination in case of graduate teacher and SS final examination in case of postgraduate teacher. Here, my lord, I am postgraduate teacher, my lord. In the school where he is a teacher, result of proceeding year of now, my lord, right hand corner, my lord, up to 60% mark pass 1 mark, 61 to 70% pass 2 marks, 71 to 80% pass 3 marks, and above 80% 4 marks, my lord. In my school, result sheet of my school is, my lord, at page 29, my lord.
No, where this mark is awarded, leadership skill.
Leadership skill, my lord, page 61, kindly say, my lord.
Column number?
Column number 9, my lord.
9 is the percentage of result of SS and SSLC last year
Yes,
examination.
sir. My, I should have granted, my lord, 4, my lord, because in my school, my lord, percentage is, my lord, more than 80, my lord.
No, that's all right, but
will-
here this mark is awarded under the column percentage of marks in SS and SSLC last year.
Percentage of result of SS and SSLC, my lord. Percentage of result, my lord. So result, I have
But
an
where it is provided this leadership skill.
page 33, my lord. Page 33, my lord.
Okay. মানে এটা কোনো নাই নেকি এই বিটিসি পোৱা নাই বিটিসি Then Kobe, let it be at okay at 2 p.m. Heard Mr. K. Bora, Learned Counsel for the petitioner. None appears for the respondent on call. List the matter again at 2 p.m.
Starting item 47.
Next is my lord. I think there are some one we can to obtain instruction.
Why you have been already granted 1 week time?
My lord. I will pursue the matter, my lord, since then.
Heard Mr. Hazarika, Learned Counsel for the petitioner, and Mr. G. Pego, Learned Standing Counsel for the respondent. King. You are appearing for? No, elementary education. Miss Fukon for respondent number 3 and 5. Miss Borua for respondent number 2. Mr. Pegu submits that he may be granted 1 week time to obtain instruction. Here is allowed to list the matter on
3rd December.
3rd of December. Mr. Pegu shall obtain necessary instruction and invariably place the same before this court on that day.
36 and 37.
Then. None appears for the petitioner on call. List the matter. Now, how about Mr. You are appearing for?
For, my lord, for the other, particular, respondents. But also the urgency is there, my lord, 2014.
Okay, again, we will list the matter at 2. We'll call it. List the matter at 2.
30 or 39?
Sir, their process is going on for areas salary manner. So sometimes it's required manner.
Process is going on.
Yes, madam. This is my instruction, madam.
Mr. Soliha, you were supposed to obtain instruction.
That section, I think.
Sanction has been granted. Furnish a copy to Mr. Pulkasta also. Good.
উনি করবো না উল্টা করবো না আই উইল সে সোজা বলে বলি যে কোথায় গিয়ে Now it is the duty of the inspector of schools mother to process the pension. The duty of the inspector of schools now. It is a duty of the inspector of schools, my lord, to further process the matter.
Now, what remains to be done?
Area salary.
Area salary. And regarding area salary, process is going on.
And NPS.
No, where, Mr. Soliha, where it is sanctioned this amount, CPF, EPF, NPS? This is not the sanction letter.
There will be a. That we have forwarded to the authorities today, lordship. I think my learned friend is also aware, lordship. This is written to the, to complete the remaining process.
That is done. This, the remaining process has been done. Thereafter, the final, my lord, has been, order has been forwarded to IS. That is the inspector. Now the duty of the inspector was to my lord to send it to the treasury for release.
The bills are.
Okay.
Regarding the answer,
And regarding area salary, it is the secondary department has to forward it to the finance department for their sanction.
What is the status of that process, Mr.?
my lord, already I have placed my lord, my instruction here. Instruction dated 2011-2025. The proposal is under process in the department and sanction will be accorded after.
That's all right. When did you receive the proposal?
We received the proposal, my lord, earlier letter dated 17/11/2025, my lord.
by letter number E 674193 only 14, my lord. So 45. It is from the director to the secretary to the government of Assam.
Heard Mr. Purkayastha, learned counsel for the petitioner, Mr. U. Sharma, learned counsel for the contender. Number. One and two,
Yes, ma'am.
and three also.
No, madam, one and.
Inspector,
Yes, three.
three. And Mr. Soleha for respondent contender number 4. During the course of deliberation,
1 and 2. I am for the contender number 1 and 2, ma'am.
1 and 2. Whether notice was served in contender number 3, Inspector of School?
Yes.
No.
Yes.
Learned friend is represented, respondent number 3, my lord, earlier also. Question.
Earlier.
Yes, communicating the instructions with the respondent number 3, my lord.
Mr. Sharma,
Within the chain, my lord. It's
so
within-
earlier you have appeared.
Same department, one is,
During the course of
Yes, ma'am. I will.
deliberation, Mr. Sharma has produced one letter dated 17/11/2025 written by the Director, Secondary Education to the Secretary to the Government of Assam for sanctioning a sum of rupees 3,81,100 being the arrear salary of the petitioner. And the matter is being processed and he press for listing the matter after
2 weeks, madam.
after 2 weeks. Further, Mr. Soleha, learned counsel for the contender number 4 has produced one letter written by the Director of Accounts and Treasuries to the Inspector of Schools, Sonitpur, in respect of the provisional
Compassionate family pension. Compassionate family pension. Lordship. That was.
where it is mentioned.
Lordship, last 3 lines of the letter, Lordship. Further, you are requested to recheck the attachment of provisional CMP, PNP by the legal and last is-
Regarding entitlement of provisional CPF stroke PFP by the legal heirs and last basic pay of the deceased subscriber before sanction of any additional benefit, stroke relief, etc. And the same has been already been communicated to the Inspector of School. And now the Inspector of School will complete the remaining process. In that view of the matter, Mr. Sharma is directed to obtain up-to-date instruction in respect of the letter dated 17/11/2025 written to the Inspector of School, Sonitpur District Circle, Dashpur, by the Director of Accounts and Treasuries, Assam. List the matter on 15 December. USSL, no, the letters produced before the court today shall be marked as Annexer B, C, and D and be tagged with the record. Okay.
Obliged.
Okay, item number 32, Lordship is looking for higher expansion losses. But this is not a higher education matter, Lordship. This is the secondary education matter.
No, higher
Education is nothing made a party and not a wrongly social. So, Lordship, please keep it on heart. The secondary education is their purchase.
Okay, anyway, we'll take up the matter at 2. You please come and press this court at 2.
Madam, I request.
So where is your affidavit?
I don't have. Because of my learned friend told me.
Pardon?
That's because of my learned friend told me, and this matter is.
So whatever, my lord.
You are
earlier,
not
my lord,
aware of.
Earlier, my lord, there were, my lord, another set of advocates were there, my lord. Now, my lord, there are, my lord, new sets of advocates. So, my lord, today.
So you obtain instruction
I will open.
and file affidavit by next week.
Lordship.
Mr. Borua, learned counsel for the petitioner, and Mr. Musahari for respondent number
3, Lordship.
3, and D. Musahari for respondent number 1 and 2, and 4, inspector of school. BTC. Then he will be for 3 and 4. 3 and 4.
Lordship, 3 and 4, Lordship.
3 and 4. Mr. Musari submits that he may be granted some time to file affidavit in opposition. Pair allowed, recess shall list the matter on
On 10th December.
10th of December. In the meantime, Mr. Musari shall file his affidavit in opposition.
Where you not? Because the higher education name has been shown.
Ah.
It should be the.
Mr. Musari, learned counsel for the secondary education department submits that in the cause list, the RESI has wrongly reflected the higher education department, and as such, a necessary correction may be.
SCBTC, Lord. SCBTC. For SCBTC, Lordship.
And the RESI shall reflect the name of SC, Standing Council Secondary Education Department, and also Standing Council for BTC in the cause list instead of the higher education department.
Pending items, 26 and
Alright.
27 for orders.
May please, your lordship. The state of Assam, Act of Secondary Education.
Lordship, we had filed a review, your lordship. Director of Secondary Education has filed his review petition, your lordship, for reviewing of your lordship's order, your lordship. The order is at page 46, your lordship. Your lordship, operating portion is at page. To your lordship. Paragraph 15, your lordship. In view of the above, the judgment and order dated 31/8/2016 in WPC number students would hold its force and the provision thereof that for the purpose of provincialization of assistant teacher science, the basis would be seniority and not the subject combination would also have to be followed. In the event the state proposition is followed, the petitioner is senior to the respondent number 6 in the matter as indicated above. It being so, the court is of the view that the order of provincializing the service of respondent number 6 would have to be declared to be contrary to the requirement of section 4 of the Act of 2011 Having declared so, it is directed that the Director of Secondary Education pass a necessary order thereof by taking into consideration that the petitioner is senior to the respondent number 6, and being senior, the provision of section 4 of the Act of 2011 would be applicable in favor of the petitioner. In doing so, the director shall follow necessary procedure under the law as required. Therefore, we were asked to direct it to initialize the service of the petitioner instead of respondent number 6, your lordship. So, lordship, after that, your lordship, a writ was also filed by respondent number 6, your lordship, and that was dismissed, your lordship, and the learned single judge's order was upheld. And then we were directed to pass the necessary orders as stated by the single judge, your lordship. However, in doing so, your lordship, we are unable to do so because by this time the 2011 Act has been declared as null and void, your lordship, as unconstitutional. And therefore, we are unable to provincialize the petitioner under the 2011 Act, your lordship. And if we have to consider him, your lordship, under the 2017 Act, what we feel is that maybe it will contradict your lordship's judgment, your lordship, which is under review. Because 2011 Act, we cannot provincialize him. Then now, if we have to consider the petition.
No, you see, whether the retrospective effect of the Act of 2017 can be given.
Lordship, retrospective effect cannot be given, your lordship.
Then you see this act is coming into force from the date
Your
on
lordship.
which it has been notified in the Gazette.
Lordship.
So it was notified in which year? 2017?
2000, yes, your lordship, it was in
17.
17. It was notified on 2017, 11 April 2017. your
Then
lordship.
if it is notified on 2017
Lordship.
and it has come into force from that day,
Lordship.
how can you apply this act to the earlier to the teachers who have been appointed under the earlier Act of 2011?
Lordship, that is what we are facing, your lordship, because we were asked to provincialize the petition under 2011 Act that has been declared null and void, your lordship. Now, because the direction is initialize the petitioner under the 2011 Act, but we cannot do so because now the Act has been declared null and void and the new Act is coming into effect, your lordship. And now we are faced by the dilemma as to under which Act to provincialize the person, your lordship. Because why? We even cannot absorb him because, your lordship, if your lordship.
No, this present act you cannot apply. It cannot stand in the way because it come into force since the year 2017 only.
Lordship. And the decision was given on 28/11/2018, your lordship.
Maybe. Merely because the decision was given after the act coming into force, you cannot.
We want to consider him. We want to provincialize him, but it will have to be under the new Act, your lordship.
No,
2017.
cannot be. You cannot be. Cannot be. Under the new act, you cannot be. It cannot be.
Whole Act we cannot, your lordship, because the respondent number 6 was already provincialized. Now the direction was to provincialize the petitioner in his post, your lordship, in the post of respondent number 6.
What
Because-
was the act prevailing prior to 2011 act?
2003 Act, your lordship.
2003 act.
3 Act, your lordship.
And if 2011 act is declared as null and void,
Lordship.
then you have to do it in the earlier act.
Lordship, or under the 2003 Act, your lordship. And earlier Act, your lordship, under the 2003 Act.
Yes, that was
So,
repealed by the 2011 act.
Yes, your lordship.
If 2011 act is declared null and void,
Yes, your
then
lordship.
what will happen? Which act will come into force? The earlier act?
No, all the acts were declared null and void, your lordship, because now.
All the acts?
Yes. 2003 act, because it was.
This is already covered by your lordship's judgment. Lordship dealt with a similar issue and dismissed the review petition. That.
Lordship, under the act which has been declared void, we cannot,
Top to be stand up.
we cannot provincialize him under the act, your lordship. Because there has to be, because.
And they have also suffered, it was, they prepared, that's number 6 prepared a writ appeal yours before the division bench.
Yes, I have stated.
Now she has stated, in the review petition, it was not stated. And that.
In the review petition, it has been stated, your lordship, it is there in
Judgment
in
was
paragraph. Lordship, we have stated in our review petition, it is, from the review petition only I have stated, your lordship, it is at paragraph number 4. Because it was dismissed, your lordship.
So thereby judgment has identified it, you're not. The earlier judgment.
We are not saying that we do not want to provincialize him, but how to provincialize him now, this is the question, your lordship, under which act, because the act has been declared null and void.
Typically, para 11, you have to delay upon the honorable Supreme Court decisions.
Earlier act was of 2003.
He was provincialized under the 2000, not 3 or lordship.
11 act. But
2011.
prior to 2011, there was 2003 act.
Lordship, after 2000, the 2011 act had come into force.
So 2011 has superseded the earlier act.
Yes, your lordship.
If 2011 act is declared as null and void, then which law will come into force?
The new one, your lordship, the 2017 act.
New one, you cannot give retrospective effect. Is it provided in the act?
Yeah, 2017 we cannot. Now 2011 is also not there, your lordship.
Then the earlier act?
Earlier act is also not there because it was superseded by the 2011 act.
But 2011 act is declared null and void.
Yes, your lordship.
Then
yes, your lordship. Now that is the problem we are facing
then
now.
the earlier act will come into force.
2003 act.
Yes.
No, because 2000 act that was superseded by 2011 act, your lordship.
Yes, 2011 act.
2003 act. 2003 act will be applicable to those persons who were at that time they were appointed.
Yes, sir. Do you have the 2003 act?
Yes, your lordship, there in the it's at page number, your lordship. Page 360, your lordship, not 360. Your lordship.
363 is the rule.
Lordship, it is at page rule will be under your lordship. This is the 1977 act, your lordship. There are some secondary education provincialization act, 1977. 1977, page 350, your lordship.
Page number?
2.
352. And the 2011 Act is at page number?
2011 Act, Your Lordship, it is, 2011 Act is at page, Your Lordship, page 07.
647. Yes. But in this act, there is no repeal and saving clause. Yes, you are referring to paragraph number?
Same contention was raised. The review petition decided by your lordship, 94 of 23. First of all, I would like to know your lordship, the same contention raised. Yes, it is already internal page 5. 7, my lord, para 6. Para 6. Para 6 last part. Internal page 7, para 6 last part. The reviewer said, and that the petitioner was not working in the school of which is mandatory for provincialization of employee under the Act of 2011. Mr. Khataniar also submitted that the Act of 2011 was declared as unlawful by this court by the order dated 23/9/2016. And as such, the petitioner as number 1 is not entitled to any benefit under the Act of 2011. This is para 6. Thereafter, my lord, your lordship will find in para 9 also. Internal page 9. Para 9, internal page 9. It appears that this code, because this review petition has been filed after 6 years. It appears that this court file order dated 23/2/2021, WPC number 596 of 2000, declared that the service of the requisition response number 1 was deemed to have been provincialized under section 4(1) of the Act of 2000. Upon conclusion arrived by the respondent therein that she was the third assistant teacher of the school concerned and under the section 3 of the Act 2000 as amended. And the third teacher is entitled to be provincialized, and accordingly it was stated that all constitutional benefit of provincialized that the petition or response number 1 may be entitled. It will be provided to within a period of 2 months from the date of receipt of certified copy of the order. So well that even under section 10(4), Government of Assam had also approved the provincialization of the response number 1. Thereafter, your lordship will find. Your lordship discuss the other things. Para 11, your lordship, regarding judicial review, para 11. Para 11. It is to be noted here that grounds for judicial review are well settled by Honorable Supreme Court in the case of Maleshwari in the following para.
No,
The case
here
was
the
taken.
question is quite different from the earlier one because in the earlier case, some other grounds were taken. But here, the ground is that they cannot provincialize the service under the 2011 Act. But it appears that the 11 Act has already been repealed by the Act of 2017. And
Same issue, your lordship. Once the judgment has attained finality, after 6 years, whether review is maintained.
after 6 years.
After 6 years, whether review is maintained. And due diligence that your lordship discussed, para 11, your lordship. Referring the Supreme Court judgment Maleshwari. And finally dismiss the review petition. And even the fundamental rule, senior cannot be superseded by a junior in the absence of anything. In the absence of anything. My lord, there are 4 of the judgments.
Okay,
your lordship judgment.
Madam, you see, this Act of 2017 came into force with effect from 14th of March 2018, on which it was published in the official gazette. So, you see, subsection 3 to section 1 it shall come into force on such date as the state government may by notification in the official gazette appoint and different date may be appointed
Lordship,
for different provision of the act,
Lordship.
right?
Yes, your lordship.
So it has come into force on 14th of March 2006 or 18. 18. Then you cannot apply this retrospectively to consider the case of the petitioner in the year 2013 or 14?
14.
14.
Lordship. Retrospective cannot give your lordship.
Cannot.
So now we,
You
if we
cannot
want,
consider their
Yes.
case under this.
yes, but we, if, then your lordship, under which act do we provincialize him? Because
The earlier act.
2003 Act, we cannot provincialize him because the act, because the order of the court is to provincialize the petitioner under the 2011 Act. Direction is such.
Because the earlier act was not superseded by any of the provision of the 2011 Act. There is no repeal and saving clause in the 2011 Act.
Because your lordship is
Similar contention they have raised in the earlier petition, para 4 your lordship have looked at. In your lordship judgment, earlier judgment. While the review petition this. Para 4 and your lordship this. Para 4 of your lordship judgment. The background fact leading to filing of the present petition are briefly stated as under. The respondent number one was the late petitioner claimed that he was appointed third assistant teacher in Savitri Borali High School, Guwahati, on 27/6/2006. And according to she claimed for provincialization of our service under the Assam Venture Educational Institution Provincialization of Services Act 2011. Thereafter, the headmaster of the school submitted the particulars of employee of the school as per provision of the Act 2011 as amended in 2012 to the district screening committee for the purpose of provincialization of their services. The name of the petitioner was initially not forwarded and she was marked as withheld in the list of eligible teachers. The order of provincialization dated 22/9/2014 was issued in respect of the employee of the school, showing the post of third assistant teacher arts as vacant. The respondent one earlier approved this by filing two writ petitions being WPC number 55613 and 214 of WPC number 65012/2015 for provision of our services. But the respondent was disposed of with the decision to consider. The respondent one again filed WPC number 596 of 2018 for provincialization of our service, and this court by order dated 23/2/2021 directed the respondent authority to provide all consequential benefit of provincialization. There also the same ground was taken. And our case is judgment is given earlier, 2018, which was upheld in 2021 by the division bench. Same facts, ma'am.
Lordship, here the school, Savitri Borali School, that has been provincialized in the year 2013. So the services will have to be provincialized under the 2011 Act, Your Lordship. It cannot be 2003 Act. School was provincialized in the year 2013. It will be under the 2011 Act, Your Lordship.
That act is no longer there.
Yes, Your Lordship. Now, if your
Then-
Lordship, if your, the question
What
that
was
your
the law prevailing earlier?
Lordship, the question that your Lordship has put that whether this person can be provincialized under the 2003 Act, Your Lordship. Because the school was provincialized in the year 2013. School itself was provincialized in the year 2013. So the services of all the teachers, teaching staff will be provincialized under the 2000. It will be considered under the 2011 Act, not under the 2003 Act, Your Lordship. So under such circumstances, Your Lordship.
No, earlier act was not repealed.
Lordship.
2003
2003 Act, Lordship. 2003 Act.
was not repealed by 2011 Act.
2011 Act, Lordship.
Then
On that, I'll have to
obtain instruction.
obtain instructions, and I'll also have to go through Your Lordship. whether
Okay, you
can-
come prepared already. Let us fix a short date.
Lordship, short.
My annual submission. Here, my lord, your lordship, because it's same thing, because here respondent number 6, who is junior to me, even in the absence of any rules, my lord. The respondent number 6 was junior to me, that was declared by the court.
No, that merit of the case has already been dealt with.
Decided, Your
Then the
Lordship.
same has attained finality
And
after being upheld by
therefore, your
the
lordship,
division
this
bench.
is the review petition. Attain finality and due diligence, they never pointed out all these things. And it is kept up to
Lordship,
the
No,
division.
no. Here the ground is quite different from the earlier one.
Lordship, here we want to provincialize the
Illegality,
petitioner.
my lord. Illegal, there is illegality, the respondent number 6.
No.
Petitioner.
We cannot go to that matter again. That has already been decided.
Decided. Already been
Now the question is, under which provision they will provincialize your service?
Yes, Your Lordship.
Her contention is that since a 2011 Act is repealed,
Subject to your lordship's approval. The respondent number 6, who was provincialized, who was junior. Only thing is that in place of respondent number 6, my case ought to have been considered. And that was the decision of the learned single judge as well as the division bench. On the basis of, this is the fundamental question. And now,
so no, you see what were the criteria under the 2003 Act for provincialization of service?
Under the three rules, your lordship.
So you come prepared?
Short date, your lordship, I'll
short date?
prepare on this.
Sorted. Heard Ms. Musarde, learned counsel for the petitioner, and Mr.
M. Chandra.
M. Sandra, learned counsel for the M. Sandra, learned counsel for the respondent. Heard in part, list the matter on
2nd December.
2nd of December.
Number 40.
Oblige, your lordship.
May I please your lordship?
4th of December. Okay, all right.
All right.
You can take back the decision you have passed before the court today. You can produce on that day.
My lord,
May I please your lordship? My lord, your lordship order dated 22/10/2025. We looked into, and till today they have not complied. I complied as per their directions, and even this on direction lordship, I appeared before the authorities, submitted all the documents.
not all.
They have all documents. Grounds they have prevented regarding my salary. I have served 34 years in the university. There's a two part of the order. One is regarding salary, another part is pension. Pension at the time of pension, releasing some documents required. That's required to be, yes, they have to check it. I submitted. But what orders prevented them to release my salary, lordship? This is a contempt petition. Last more than 1 year has done. Writ appeal has been dismissed. Review petition has been dismissed. And I am suffering acute financial hardship.
So at what stage it is pending,
Great.
Mr. Pokon?
Sir, the process for computing the amount, one come, it is on, my lord. But whether he is gainfully employed or not, as per FR 54A, my lord, he has been asked to file an affidavit. But he could not file that affidavit. Another date has been fixed on 28th.
Of this month.
Yes.
Part 56 regarding suspension period. Here is the direction, kindly we look into lordship. What is this?
That has
Is
been
the termination of service, is not suspension.
day before yesterday.
Page 27, paragraph 36, 37 may be looked into lordship of the directions of this report.
Mr. Bormoya,
Lordship, I'm a
you
great.
filed the affidavit there.
I have submitted application.
Affidavit?
Yes. Lordship, I submitted an application.
No, no,
for
no,
them,
they
lordship,
request
that
one
I have
affidavit.
not gainfully any employed. That application I have given to them.
Application or affidavit?
Application I have, sir.
No, they, what they request is
And
affidavit.
verbally
You-
I have also.
You file on affidavit?
Yes, lordship. Yes, certainly I will submit. But question is that that is not required. I am not suspended. My
No,
service.
that's
was
late.
terminated.
Uh,
And I verbally stated I have not done any job in that period.
maybe it may require for their audit also.
Lordship.
Because
I verbally
here,
stated and my on signed it also.
you
I have
find
not
a,
done
file an affidavit, thereafter we'll see if they fail to release the benefits.
Benny regarding lordship, salaries part not required. Salaries part, there is two part of direction. Once in the proceeding, writ proceeding, I retired. I challenged the termination. The termination has been set aside. And court directed the absence period, I am not entitled for the salaries. But after that period, for 3 years, more than 3 years, directed to pay the salaries for that period. So what orders prevented them to release their salary? I
compute the
served.
amount of the salary. As affidavit is directed. To compute the amount, the quantum.
Lordship, kindly look into the order of the court, page 27.
No,
paragraph.
no, Mr. Bormoya, first you submit the affidavit as required by them.
I will submit on
Okay.
Monday, direct him to release the order before next Friday.
Yes, yes, yes.
Yes,
Yes.
I'll submit the.
You file it on Monday, next Monday,
Today is the Friday.
Friday.
On Monday, I will submit that affidavit and direct him to complete
you know, the last two lines, you know. Therefore, you are hereby directed to submit the required affidavit, appearing personally before the Guardian of the authority on 28/11, next Friday.
Next Friday.
Your
Then
lordship-
after 1 week,
Lordship,
after 1 week.
submitting, I will submit on Monday. Why they have not released?
No, here
If
the
I
date
brought
has
it-
been fixed on 28.
28.
They have fixed, Lordship, but
Hmm.
even I can submit before that also, Lordship. I will submit
Okay,
it.
okay.
I am, on Monday, I will provide, ask him to provide on 28,
Hmm.
11. My salary, I am for 5, 6 years, Lordship, out of service.
Okay.
Intermediate retired also. Question is the financial hardship.
FR 54A, you know.
A great
First,
a
that
proof
quantum would be, you know, determined by the authorities concerned.
Hmm.
Then it should be, you know, that a notice should be sent to the, you know, petitioner concerned. Within 60 days, you know, he will respond, you know, whether that amount is, that quantum, you know, of the area salary is correct or not. And within 60 days, you know, the entire amount will have to be released as per FR 54A.
Hmm.
If there is a court.
No, maybe, but
that part-
That 60 days part, you know, only that affidavit that he is not gainfully employed in a private or government job.
okay.
That is.
But not 60 days, you will release it within 1 week from the date of receipt of the affidavit.
Yes.
So, you know, the, some time.
No,
requires
no, no,
at least
no,
2
no.
weeks, you know, after.
No, no,
the
the
affidavit.
person retired in the year
Retired in the year, Lordship terminated in the year 2019.
19.
Retired 2024, during the
24.
termination period. And Lordship, that's why I looked into paragraph
So,
36
no,
and 37.
Mr. Fukan,
You know,
it is improper to drag him to your office after the retirement.
Retired
You
on
release
31
the
and terminated, Lordship.
entire
2 years.
amount he is entitled to
You know,
after within a period of 1 week from the date of filing of the affidavit.
Yes,
We are giving you 1 week time.
at least 2 weeks, you know, otherwise.
Lordship, a
Come
proof, Lordship.
Okay,
I
all
got
right.
proof, Lordship.
But
Allah.
you have to produce the compliance order by next date.
You know.
Okay. Heard, Mr. Barbhunya, learned counsel for the petitioner, and Mr. Fukan, learned standing counsel. No, learned counsel for the contender. Mr. Fukan has produced one letter of the register addressed to the petitioner dated 19/11/2025, indicating that the petitioner has to file an affidavit appearing personally before the authority on 28/11/2025 that he has not been gainfully employed elsewhere during the period of
Period from 2006 to 2019, up to 31/1/2024.
from 2000 from the year
2019
6 to 2019 till
up to 31 January.
31/1/2024. 2024. Mr. Barbhunya submits that by Monday, next Monday, he will file the affidavit, and he submits that the contender may be directed to release the service benefit of the petitioner by next week. However, Mr. Fukan, learned counsel for the contender, submits that at least 2 week time may be granted to the contender to comply with the order accordingly.
After having the affidavit.
After getting the affidavit from the petitioner. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that rest shall list the matter on COVID
On 10th December.
Prior to that, Lordship.
10th of December. 10th of December, and by next Monday, that is 24th of November, the petitioner shall file his affidavit before the contender. The letter produced before the court today shall be marked as Annexure B and be tagged with the record. List the matter accordingly.
Item 41.
Next, কোন তারিখে দিছে?
10 তারিখ বুধবার। কপিটা টেন্ডার না
Lordship, kindly peruse the last order of this honorable court, dated 10/11/2025.
Here, I have if the instruction of that is some date is wrongly recorded, so can it be on Monday?
Your Lordship, orders, direction was at page 12, relevant, Your Lordship. Para 7 is read. They did not provincialize the service of the petitioner on the ground that there is a dispute in the land of the school. In the first round of litigation, in terms of the order of the first round of litigation, that part has already been decided by the authorities, saying that the school is having land. Now, Lordship, in this writ petition, the Lordship has directed to provincialize service within 45 days, subject to confirmation of the other documents. Now they are taking that the earlier plea that the school has no land. In fact, their own decision in the speaking order upon hearing all the parties in terms of the earlier round of litigation.
Monday. Okay, Monday. Heard Mr. Khan, learned counsel for the petitioner, and Mr. P.K. Bora, learned counsel for the contender. Mr. Bora, praise for listing the matter on Monday. They are allowed, SSL is the matter. Tuesday.
My lord, can it be on Wednesday, Lordship? I think.
Wednesday.
Yes. 28. 26, yes.
Okay.
Obliged.
42.
Please, Your Lordship. Lordship, for office note date 19/11/2025, AD and notice has been unserved, not returned, Your Lordship. I may be allowed to take fresh steps.
Fresh step.
Lord,
Heard
by
Mr.
way of
Your
the-
good name?
S. Gautam, Your Lordship.
S. Gautam, learned counsel for the petitioner. Office note dated 29/11/2025 indicates that neither ID card nor unserved notice returned to the section. The learned counsel for the petitioner submits that he may be allowed to take fresh step upon the respondent. Pair allowed shall be taken by registered post with AD and also by usual process within a week from today.
Lordship, Dusty may be
Additionally,
allowed.
Dusty service is also permitted. After effecting service by Dusty mode, the petitioner shall file an affidavit before this court. List the matter on
December, third week of December.
15th December.
15th of December.
Oblige, Your Lordship.
140.
My please, Lordship.
Please, the lordship, the instruction is that we have submitted for re-sanctioning of the amount, your lordship. Medical reimbursement. It was sent to the government on 1/11/2025, your lordship.
1/11/2025.
Lordship will give me 2 weeks' time, your lordship, I'll place the up-to-date instructions as for what has happened, your lordship.
No, madam, you see, if it is sent on 1/11/2025, then why so much time is required?
Lordship, I inquired, your lordship, the instruction is awaited from the government, your lordship.
That's all right. You obtain
Time, your
1 week time.
1 week.
Yes, any objection?
No, my lord. Date may be given.
Heard, Mr.
A. Hussain, yes.
A. Hussain, learned counsel for the petitioner. And also heard Ms. Musahare, learned standing counsel for the respondent authorities. Ms. Musahare has produced one letter of the director dated 1/11/2025, addressed to the Secretary to the Governor of Assam, requesting to sanction a sum of rupees 4,37,829 rupees, being the medical reimbursement bill in respect of the late husband of the petitioner. And on the basis of the said letter, she submits that the matter may be listed after 1 week so as to enable her to obtain up-to-date instruction in respect of the said letter dated 1/11/2025. They are allowed, let's just list the matter on 3rd of December. The letter produced before the court today shall be marked as Annex RA and be taken to the record. Any other matter?